Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
That was Bryan Kohberger pleading guilty to the brutal murders of 4 University of Idaho students. Now he says he didn't do it. In a new bombshell court filing, he's claiming he was coerced. Plus, I'm going to tell you what the convicted murderer is saying from behind prison walls and share outrage from one of the victim's family members. I'm Angenette Levy, and this is Crime Fix. Bryan Kohberger wants to go back to court because he now says he is actually innocent. Yes, this is not a test. This is not a joke. Bryan Kohberger, after pleading guilty to the murders of 4 University of Idaho students, has filed a petition for post-conviction relief in Ada County, and we have all of the details for you. The 4 victims, who became known online as the Idaho 4, Maddie Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle, were brutally murdered in the early morning hours of November 13th, 2022. The now famous porch photo, that's what I call it. We've all seen it. It shows those friends happy and smiling just hours before their lives were taken. The small-town police force in Moscow, Idaho, where the University of Idaho is located, had the overwhelming task of tracking down whomever brutally stabbed the 4 college students in their shared off-campus home. A critical piece of evidence was discovered next to one of the victims, the sheath to a K-bar knife with the U.S. Marine Corps emblem on it. Testing done on that sheath would be the key that would unlock the case. After weeks of investigation, the police announced that they had their man, but he wasn't in Idaho anymore. Bryan Kohberger was back home in Pennsylvania for winter break with his parents. Kohberger was a doctoral student at nearby Washington State University, studying, of all things, criminology. According to prosecutors, Kohberger's DNA was found on the knife sheath left behind at the scene. His Amazon purchase records also showed that he'd bought that type of knife and a sheath to go with it months earlier. After Kohberger was arrested and brought back to Idaho, pre-trial hearings and status conferences went on in Latah and Ada counties for months and months. Kohberger and his defense team insisted that he was innocent, but it all culminated in Kohberger deciding to enter a guilty plea. Just weeks before his trial was set to begin, he was sentenced to 4 consecutive life sentences. He's been locked up in a maximum security prison ever since, but now he wants out, and he's trying to take back his guilty plea. Here's a look back at that.
Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
As part of Kohberger's plea agreement that removed the death penalty as a possible sentence, he waived his appeals.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
But in this new petition for post-conviction relief, Kohberger makes a complete about-face, taking back what he said in court last year. This new filing comes 2 days before Netflix is set to drop a new documentary on the case, which features interviews with Moscow's police chief and the family of Kaylee Goncalves. As part of Kohberger's guilty plea, he wasn't required to make a proffer. That's a statement where a defendant lays out facts of the crime. In a proffer, those statements cannot be used against a defendant in court. I asked prosecutor Bill Thompson about the decision to not get a proffer from Kohberger last year. You know, I asked you this at the press conference. You said under the law, you can't be compelled to force him to allocute. But why not get a proffer from him? You know, hey, Ann, like we'll let him plead, but we need to know where he put the knife and how he got through the house and everything like that. Answer a few questions. Why didn't you ask for a proffer?
Well, we talked about that among the attorney team, and we made a decision that we wanted to make sure that the guilty plea itself was solid if he was going to plead guilty. Our experience, and Judge Hippler talked about this as well, is that frequently when defendants are being asked to explain, they start to minimize what occurred. They can't be trusted for the truthfulness of what they say. And we elected, in order to ensure a solid, sustainable guilty plea to all the counts, that we would not press for more than what the court was going to require as far as the defendant admitting to the truth of the charges.
But a proffer, I mean, you could have then rejected it and said, okay, we're going to trial. If you thought he was minimizing and lying, if you thought he was being dishonest, and he could have led you to the murder weapon.
I hear what you're saying, Angenette, and he could have. We don't know if he would have or not. I don't think it would have changed the ultimate outcome. And our interest really is if we were going to be able to lock down a guaranteed result for the families and for the public, that was the focus. Mm-hmm. And we also reflected back to early on, I don't know if you're aware of this, but early on, when the FBI first came on board with this case, they sent agents from their behavioral analysis unit, their profilers, to work with us. And they told us that based on what they were seeing about the nature of the crime scene, the crimes themselves, that even if we were to get the person who committed these crimes to try to explain why it happened, that it wouldn't make sense to normal people like us, and that they really can't be trusted to tell the truth because people like this live in their own different world, which is completely foreign to what we as normal people understand and can process. So that was a factor as well in our thoughts. This was probably one of the most bizarre cases I think that we've ever seen. And that sentiment was shared by experienced investigators who were working on the case from the very beginning.
So Bill Thompson said agents with the FBI's Behavioral Analysis Unit told him and investigators that the person who murdered Kaylee, Maddie, Ethan, and Xana couldn't be trusted to tell the truth. But Bryan Kohberger has told the New York Times that he's making an absolute claim of innocence. And we have an affidavit signed by Bryan Kohberger that he filed with his petition for post-conviction relief. In it, Kohberger states, "It is hereby declared that during attorney-client discussions, most of which included all members of Bryan C. Kohberger's immediate family, petitioner was convinced to falsely confess to capital murder and felony burglary by coercion, disinformation, false promises, and the withholding of exculpatory discovery. The following is material to the inception of the plea. Counsel's failure to inform petitioner of exculpatory discovery he received during plea discussions, namely clumps of unknown hair found in Ethan Chapin's hands, as well as a failure of further inquiry. Number two, petitioner was convinced that actual guilt was not an important factor in considering a plea acceptance. Death row was imminent and advised to lie. Petitioner was to get a legal victory in entering a false plea. Number 3, a gross misrepresentation of and promises regarding what a life sentence would immediately afford petitioner, and a gross misrepresentation of death row in Idaho, including an elaborate story of counsel's horrific experience touring an actual 8x8 death row cell, all communicated to petitioner and his family, allegedly by IDOC through counsel, thus constituting threats and promises made to induce a plea agreement. The New York Times says Kohberger passed a statement to them by way of his family. Kohberger wrote, "Over a year later, it is self-evident that, in State v. Kohberger, justice was not served. Unanswered questions seem to multiply with each piece of discovery unsealed, and the public demands the truth. Unfortunately, the truth shall never be derived from the state's myopic narrative, a work of fiction which has yet to evolve since the PCA was released nearly 4 years ago, and its faulty premises were never challenged at trial. Circumnavigated by a broken plea, the trial never provided the public the clarity conducive to closure, and justice shall remain abjectly miscarried unless that plea is withdrawn. I hereby declare my intention to enter a not guilty plea and welcome the state the opportunity to prove their case at trial, as well as to, again, file for the death penalty. My actual innocence is my truth, and the plea, hinged on by false promises and blatant disinformation, must be withdrawn. Thank you for all who believe in my innocence and continue to critically analyze the case. I send my love to my family who have never wavered in their belief in who I am, their belief in my innocence." So let's break this down. I want to bring in Mark Weaver. He is a special prosecutor in the state of Ohio. He's prosecuted death penalty cases and talked about this case with me many, many times. Mark, I don't know about you. I'm not surprised by this. I've been saying for a long time I didn't think this was the last we were going to hear of Bryan Kohberger, and now here we have this petition filed.
Yeah, remember, every defendant in prison has two things: a lot of free time and access to a free law library with lots of forms that they can fill out to file things. And so that's why we have so much prisoner litigation. I don't think this is going to go anywhere, but we can certainly analyze it.
Let's talk about why you don't think it's going to go anywhere. Obviously, this is a handwritten petition that Bryan Kohberger has filed on his own. We know there are plenty of jailhouse lawyers out there, prison lawyers. He's in there. He was working on his PhD in criminology. I'm sure prison is not fun. We know that he has not been enjoying prison at all based on some of the things we reported a long time ago about his complaints to the correctional staff there. So what's your analysis of this petition? He is basically saying he had meetings with his legal team and most of his immediate family members, and he was convinced and coerced to lie and to falsely confess. He was convinced that this would be a legal victory.
Yeah, let's unpack it. First of all, when you plead guilty, you give up most of your appellate rights. That's different than if you go to a trial and the jury convicts you. There's a different array of appellate rights available in that case. So when you plead guilty, you are giving up a lot of appellate rights. Second of all, there's a 42-day window in Idaho when you have to file your motion to withdraw your plea. That came and went last year. So he can't file a typical motion to withdraw a guilty plea, even though those rarely work. He's left with what we call PCR, post-conviction relief. Most defendants file motions for post-conviction relief. Rarely are these things granted. The standard was the representation by his defense counsel so bad, so ineffective, that when he was answering questions with the judge, that he didn't even know what he was being asked. It's probably not going to be granted for a couple of reasons. One is I didn't like his lawyers very much, but they were pretty effective. They got him off the death penalty. And number two, if there's anybody who ought to understand a judge's questions, and I sit as an acting judge sometimes when the local municipal court judge is out on training, so I've done thousands of these, the judge has to ask the defendant a question over and over again. Do you understand this? Do you understand that? You're giving up this right. You're giving up that right. If there's anybody who understands that it's someone in a PhD program for criminal justice. So the notion that he didn't know what he was doing, rather far-fetched.
He is a smart guy, but I go back to his attorneys. They kept saying they questioned his competency and they monitored his competency. They said he had level 1 autism, used to be called Asperger's disorder. What are the chances that his lawyers were aware at all that he was going to do this? Because he, his lawyers, they've never said a peep about this. I think they've issued one statement where they called out one of their defense experts for coming out and basically saying that he believed Bryan Kohberger was innocent.
Yeah, ironically, when you allege ineffective assistance of counsel, you have to get a new set of lawyers to do that, or you couldn't have the same lawyers who were allegedly so ineffective represent you on appeal. He's currently filing this by himself, but I wouldn't be surprised if his family or his sister or somebody found some lawyer to actually litigate for him after he's filed this. Notions of competency are heard ahead of a trial, certainly ahead of any plea. And the lawyers tried that. They tried raising that. The judge didn't find any merit to that. So we have no reason to think he's incompetent to stand trial. Nearly everybody who murders people has something a little bit wrong in their head. Not everybody. There's some perfectly healthy people who do it for love or money or power or whatever. But most people who slaughter others with a knife, particularly 4 of them at night and doing all the creepy things he did, have a little something wrong. But that's not enough to overturn your guilty plea.
He is basically saying that he was coerced into doing this, that there have been misrepresentations. He said there was a story of a horrific experience and all of this stuff. He says there is more information that has come out with all of this stuff being unsealed now by the courts that we're now seeing that shows that he was innocent. Where do you think he is getting this?
Well, again, a lot of free time, a creative mind, and full access to a law library with all the cases, and you could put all sorts of theories together. Whatever he is saying that is coming out to public now was known by him and his lawyers because they would have received it through the criminal discovery process. So there's no new information that he didn't know. It might be new to us, but it wasn't new to him and his lawyers. And I think, I've gone to prisons and talked to people in prisons that have gotten tours and that sort of stuff. And when you talk to them, nearly everyone in there will tell you they didn't get a fair trial. And they've got some long-winded theory about why it wasn't fair because they've got nothing but time to think about it. But that's not the standard. The standard for post-conviction relief is, can he prove that there was such an effective assistance of counsel that he didn't know what it means to plead guilty. And he didn't know what he was pleading guilty to. And there are cases out there of people with 5th grade educations who've been found to understand those questions. Certainly somebody who's in a PhD program in criminal justice understands those questions.
Interesting. One thing you and I have talked about many times is the fact that Bryan Kohberger, as a condition of this plea, was never told, okay, we need you to sit down and make a proffer and answer some questions for us and give us information. Where's the K-bar knife? Where's the murder weapon? Where are the clothes? He was never required to do that. That can be a condition of a plea. And I played the clip from Bill Thompson earlier here in the podcast showing his answer to me about that. What are your thoughts now? Now we have this more than a year later after the sentencing or after the guilty plea and the sentencing. What do you make of this? Like, does this show that a mistake was made?
Yeah, first of all, your viewers should know nobody's covering this case like you are. You raised this last year. We talked about it at least twice, maybe 3 times. And I hate to be critical of fellow prosecutors because most of my legal work involves prosecution. And there may be things we don't know about what the prosecutor knows. But the prosecutor could have said to defense counsel, we're not taking the death penalty off the table until, number 1, he pleads guilty, obviously. And number 2, he gives a detailed accounting in open court in front of everybody as to what he did, how he did it, and to the extent possible, why he did it. That would have given great closure, maybe not complete closure to the families, but some closure. And it would have forestalled this ridiculous post-conviction relief notice that post-relief conviction filing that somehow he didn't know what he was doing when he pled guilty.
We should take now a look at the statement issued by the family of victim Kaylee Goncalves. They put this up on Facebook, and they are seething. Let's read this. First off, we are not surprised, even though Bill Thompson said with the plea deal, all appeals would be waived. We knew that wasn't factual. Anyway, his time to plea was running out, September to be exact. They're saying there was a September deadline. Goncalves' family statement states, the mosquito you just can't seem to swat. That is what Kohberger and his following have become to this family. We read Mr. Baker's story, and he must be so proud of himself for speaking with Mr. Kohberger, because the story didn't have much else in it other than a guilty man claiming he is innocent once again. Nothing in the story or in Kohberger's statements does he allude to the fact that he did not knowingly, voluntarily, and intelligently admit to murdering the 4 victims of this tragedy, Kaylee, Maddie, Xana, and Ethan. Quite to the contrary, he appeared in court in a hearing in front of a judge with his 4 lawyers. He did this after deciding not to leave his fate and the facts of the case up to a jury to decide his guilt. He never cried wolf or claimed he was uninformed, pressured, or that there were issues with the discovery that he and his counsel had for 2 years that he thought should have been challenged. He admitted to guilt and asked whether he actually was guilty. He said, yes, I am sure there will be a hearing, as that is how the legal process works, and the defendant will get another day in court. What do you make of the statement from the Goncalves family?
That's the first I've heard that. First of all, that's a powerful metaphor of mosquito, because a mosquito can draw blood, and a mosquito has no real good purpose out there other than to harass and annoy. And this feels like re-victimization, doesn't it? And certainly none of us can understand what it's like for that family to have this brought up again, just as they're putting a little bit of this in the rearview mirror. Their statement also does lay out the proper timing for a motion to withdraw a guilty plea would have been last September, and the standard by which those are judged, which is whether or not the defendant made a knowing, voluntary, and intelligent waiver of his rights when he pled guilty. During these change of plea hearings, and I've sat through countless of them over the years, judges take a long time to make sure that every single question asked is fully understood by the defendant and that the answer is voluntary, knowing, and intelligent. I don't think there's any doubt that happened in this case. But once again, Bryan Kohberger would like to not be in prison. He now realizes how his life is going to be hell for a long time because his fellow inmates know that what he did. And as a result, he's twisting and turning and trying to find a way out of this. I don't think it'll be successful.
Will he get a hearing?
Well, that's interesting. In motions for post-conviction relief, there is not a requirement to have a hearing. A judge can do what's called a summary dismissal. That is, looking at the papers and deciding that the prosecution doesn't even need to respond. I worked on a case last year, a felony prosecution. I recently got notice that the defendant had filed a motion for a post-conviction relief. The judge doesn't have to grant that hearing if on the papers the judge doesn't see anything worth having a hearing about. I don't practice in Idaho, but I imagine it's the same there. So a post-conviction relief process does not require a hearing, but it often has one. If for no other reason, it shows other courts of appeals that each judge took the time to carefully review each of the filings.
It really is stunning. We'll wait to see what comes of this. I'm, again, not surprised by it at all. I always thought without a proffer that we might be in this place. Mark Weaver, thank you so much for coming on and for offering your expertise, as always.
Yes, thank you, Angenette.
So let's take a look at the rest of the statement from Kaylee Goncalves' family. It reads, I am sure there will be a hearing, as that is how the legal process works, and the defendant will get another day in court. A nice break from his solitary confinement, getting to go for a ride, maybe some different food, photos taken, and the intention all back on him and his, quote, innocence. The real issue is that if as much energy was put into honoring the victims in this case as trying to set a guilty man free, there would be statues of the victims on every corner with parks and days honoring their ultimate sacrifice, their lives, at the hands of a narcissist. Regardless of how this turns out, our family is 100% ready. An actual trial this time? Let's go. We are confident he will get the death penalty that he escaped by pleading guilty the first time around. Moving on, LOL. Just an absolute waste of time and taxpayers' money. It's a disgrace. I guess I better get me a death row record shirt for every day of the week now. At the time of this recording, prosecutors have not responded to the petition. Bryan Kohberger remains in Idaho's maximum security institution in Kuna in solitary confinement. And we're going to stay on top of this and let you know what happens. That's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with me. I'll see you back here next time.